Major breaking news out of the state of Michigan. A court of appeals from the state of Michigan has declared that the University of Michigan's law or ordinance that bans guns on campus, with only very few exceptions for people like military and law enforcement, that law, that gun ban, is indeed constitutional under the Second Amendment. So says the Michigan Court of Appeals. Did they get it right? Hardly. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. I would appreciate, posting reviews if you're willing to do so. It makes a big difference to help build the credibility of this channel and my work, so I would appreciate it to the extent you're willing to do so. Okay, now let's turn to the breaking news. The Michigan Court of Appeals has decided a case called Wade versus the University of Michigan. This was a case that was started in 2015. It ultimately gave rise to what we just see today, which is two judges, a two-judge panel. It was kind of a three-judge panel, but one of them apparently retired. So it's turned out that right now it's a two-judge panel, concluded that the gun ban on the campus and anything associated with the University of Michigan, that gun ban on any property associated with the University of Michigan, leased by Michigan, used by Michigan, University of Michigan specifically, that's constitutional and does not violate the Second Amendment. To begin with, let's talk about the ordinance that's in play here. Specifically, the ordinance that was being challenged applies to all property owned, leased, or otherwise controlled by the Regents of the University of Michigan, and applies whether an individual has a concealed carry permit or not. There are some exceptions for people like university employees, presumably security guards, university law enforcement, just police generally, military, folks like that. So again, there are some narrow exceptions, but for all intents and purposes, guns are banned on the University of Michigan campus. Now, this is a wrong decision, and I'm going to tell you why right up front, and then we're going to get into a little bit more geeky details. The reason why this is wrong is because this court embraced language from Section 3 of the Heller versus the District of Columbia decision that talk generally about quote-unquote sensitive places and reference government buildings and schools. Now, this was, as you know from this channel, this was a passing reference, what is known as dicta. It was not central to the case, meaning central to the holding of the case, which, as you know, all Heller decided at the end of the day was that the Second Amendment protected individual rights to keep and bear arms, that an individual has a right to a loaded handgun in his home that's unlocked and ready for self-defense, and that if a arm, any kind of firearm, but if an arm is in common use today in America for lawful purposes by Americans, it is protected and cannot be banned. That was the holding. Those were the key holdings in the Heller case. Now, as part of that long discussion and discussing various other aspects, there is a section that talks about nothing about this case, specifically what the court said, quote, although we do not undertake an exhaustive historical analysis today, that's what the Supreme Court said in Heller, today, of the full scope of the Second Amendment. Makes sense, right? Because they were only trying to figure out whether or not the D.C. gun ban was constitutional, and they said it was not. This is what the court again said. Although we do not undertake an exhaustive historical analysis today, in the year of our Lord 2008, of the full scope of the Second Amendment, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons or the mentally ill, or laws forbidding, this is the key, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. So all they're saying in this case of Heller is, as an aside, the Heller decision itself does not speak to these other issues. That's all they're saying. They're not finding anything, nor could they make such a determination in a robust way because it wasn't being litigated. The question was whether or not you could have a handgun in the home in Heller. So they didn't need to get into all sorts of other discussions, such as these other issues, which of course, as we know, are being litigated as we speak. Nevertheless, what the Court of Appeals did here in Michigan to uphold the Michigan ban on guns at the University of Michigan campus, which is broad and everywhere apparently according to the allegations of the complaint, What they said is this language from Heller in 2008 says that sensitive places include schools and government buildings. Then they go on to say, hey, guess what? The University of Michigan is obviously a school. No, duh. Of course the University of Michigan is a school. You don't need to do a big analysis of that. Any moron can tell you that's the case. But that's not the issue. The issue is, what was the law that the Supreme Court relied on to conclude that there are such things as sensitive places at the time of the founding where guns could be banned? Well, you don't get the answer that can resolve this Michigan case from Heller, because this language in Heller is simply dicta, a passing reference that has some insight, has some value, but really just kind of a more of a passing reference in the middle of a lecture, not central to the holding. Okay? So then they turn to Bruin and they try to say that, oh, well, Bruin reaffirmed that critical language in Heller. But if you read Bruin carefully, and then you'll see why this does not help the University of Michigan defend their gun ban. If you read Bruin carefully, it says, it references this Heller language about longstanding laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. But then it goes on, and this is the key. It says, quote, Nysurper versus Bruin, Supreme Court. Quote, although the historical record yields relatively few 18th and 19th century sensitive places where weapons were altogether prohibited, e.g., listen carefully, legislative assemblies, such as Congress, polling places, short period, 8 hours, single place, maybe, and courthouses, legislative assemblies, polling places, and courthouses. We are also unaware of no disputes regarding the lawfulness of such prohibitions for those 3 places. Do you see what happened here? So in Heller, you have a passing reference to government buildings and schools without any real analysis, kind of just talking about in the context of how to think about Heller going forward in the Second Amendment context. Then in Bruin, there's a little bit more clarification, and they literally narrow it down and say, legislative assemblies, polling places, and courthouses is where you can't have guns as the Supreme Court sees it. But what this court does is the following. They say, oh, well, we're going to look at Heller, and Heller says that gun bans on schools and government buildings are constitutional. But here's what this court failed to do. This court failed to look at the cases, the legal authorities cited and relied upon by the U.S. Supreme Court in concluding that legislative assemblies, polling places, and courthouses, you can't have guns. And they also failed to look at the discussions of sensitive places. Because if they had done so, they would have seen the references to certain universities and schools actually mentioned in the Bruin decision. But guess what? Guess what? Do you know what those cases, those laws at the time of the founding talk about when they discuss gun bans on school grounds? They're talking about the students. That's right. Every single law dealing with gun bans at the time of the founding on campus speaks to students could not have guns on campus, if anyone. And the reason why is back at the time of the founding, you had 14, 15, 16-year-old kids on campus. And you have a doctrine going all the way back hundreds of years called in loco parentis. In loco parentis, which is Latin for simply in place of the parents. In loco parentis means in place of the parents. At the time of the founding, the universities took the place of the parents of the students that attended those universities, because in many instances, the students at these universities were literally children, because they were like 14, 15, and 16 years of age. They were little kids in some ways at these universities, and the universities viewed them as their own children under the doctrine of in loco parentis. But do you know who was not banned from having guns on campus? Everyone else. Adult faculty, adult staff members, members of the public. The people that were prevented from having guns on campus at the time of the founding at these schools were the children under the doctrine of in loco parentis, which only applies to children. Because once you're an adult, you don't have a relationship where you're the child. I suppose there could technically be an exception if you're mentally ill, if you're mentally ill, frankly, and you can't take care of yourself because you're mentally ill. Well, that would be an example where an adult could have somebody that looks after them under the notion of in loco parentis. But when you're dealing with gun bans on campuses of schools, you're dealing with bans involving students. Now, did this court, the Michigan Court of Appeals, make that distinction and read these cases like you should as a first-year law student? No, they did not. And we know they got this wrong because if you look at section number 1, defined as scope of Article 10, Roman numeral 10, which is the relevant ordinance being challenged here, and also if you look at section 2, it specifically says no person shall, while on the property, leased or otherwise, have a gun. No person. It does not draw that distinction, this ordinance, between adults and faculty members and staff members at the University of Michigan versus the students. The only authority that Bruin cites to talk about sensitive places in this context were laws or ordinances or school regulations dealing with students on campus not being able to have guns, not anybody else. Did this court even try to explain that away? Did this court talk about the authority that Heller or Bruin relied upon at the level that I just did? No, they did not. I wonder why. Inquiring minds want to know. I think we probably know the answer. Now, to show you how this court tried to get around what I'm saying, to make themselves look like they were doing the analysis, they did some things right. Specifically, they did conclude correctly that the plaintiff's conduct is covered by the Second Amendment as a matter of text, because the text of the Second Amendment, the operative text, is the right of the people to keep and bear arms shall not be infringed. Obviously, banning Mr. Wade here from being able to carry a gun on the University of Michigan campus is indeed infringing or impacting his right to keep and bear arms, because he can't carry a gun, he can't bear arms on that campus. So that is indeed touching fingers with implicating the text of the Second Amendment. So once that happens, the burden shifts to the government to come up with a historical analog law, specifically laws to show a historical tradition, that you could ban these guns on campus. But again, they then screw up because they ask a question that is really begging the question presented in this case by Mr. Wade. So on page 10 and 11, the court asks whether the university is a school or government building. It then goes on to talk about these things are schools at the time of the founding. They quote Samuel Johnson, Black's Law Dictionary, some of these other things to prove the boring point that universities are schools. Obviously, universities are schools and places of education. That's not the question, though. That begs the question. And the question presented by Mr. Wade in this case is whether adults who are not students can carry guns on the University of Michigan property. Okay? There's also an argument about students, but set that issue aside. At a minimum, can adults who are concealed carry holders in the state of Michigan, but who are not students, carry guns on campus under the Second Amendment? Because the University of Michigan is a state actor. It is a government actor. So if they're banning you from carrying guns, it implicates the text of the Second Amendment because they are the government, not private actors. The University of Michigan is owned, controlled by the state of Michigan, which is a government and therefore covered by the Second Amendment and the 14th Amendment. The Second Amendment specifically incorporated through the 14th Amendment applies to the University of Michigan and all Michigan government agencies. Now, the only two other points I want to make before I wrap up this video is there was a very interesting concurring opinion by the Michigan Supreme Court after Bruin came out, because this Wade versus Michigan case had already gone up to the Michigan Supreme Court and was sent back after Bruin for further analysis, which this Court of Appeals just did. One of the judges on the Michigan Court of Appeals, Justice Viviano, he had two questions that he wanted the lower courts to answer. The first is, should the courts consider whether there were any analogous firearm regulations on university and college campuses in the relevant historical period? That's the first question, which goes back to, yes, there were. Specifically, students did not have a right to carry guns on campus, because they were students and in many respects children under the doctrine of in loco parentis. The schools had the ability to take guns away from the students in the same way that the parents had the authority to take guns away from children, because in many instances the kids on campus were children. That's how young they were. So that's the first question that Justice Viviano asked the Court of Appeals to address. The second one, and this is quite an interesting question, this court should consider whether large modern campuses like the universities are so dispersed and multifaceted that a total campus ban would now cover areas that historically would not have any restrictions at all. Okay? Now, this is very important. For those of you who most of you probably don't do this, but I'm in and around college campuses all around the world. I have a sense of these things, and I can tell you when I go to speak on a fancy college campus, like I just have off the top of my head, if you go to Harvard, if you go to the University of Pennsylvania, these campuses are not quaint little places anymore. They are massive, and they're growing, and they're everywhere. So for example, where I went to law school, NYU, the campus goes on for blocks and blocks and blocks. There's so many buildings that NYU owns in Greenwich Village, it's hard to know when you're standing beside just a commercial office building versus the NYU building. So Justice Viviano asked a great question about these modern universities. These are no longer these confined little New England quaint campuses where there's 10 buildings around a beautiful quad or something like this. No, they're all over some of these places in these major cities. They take up so much room. There's so many buildings. There's so many things going on, parking lots and everything else. These huge stadiums and baseball fields and football fields and hockey rinks. These are little mini cities. So I think Justice Viviano asked a great question about whether, laws at the time of the founding dealing with quaint little college campuses have any relevance to these megalopolis quasi-city style modern day universities. And I think it's a great question. But again, in this instance, the Court of Appeals did not need to get to any of this because the laws they should have relied upon and looked carefully at was the ones that Heller and Bruin talked about. And those, again, only allowed for the banning of guns by students. And keep the following in mind. When you're looking at these sensitive places and other laws referenced in, for example, Heller, where they say, well, nothing about this case is putting into question these long-standing prohibitions on these various items, such as bans on guns in, government buildings or schools or involving felons. Here's the key you got to understand. All the court is saying there is at the moment of time in 2008, they're presumptively allowed. Those laws that were referenced there are presumptively constitutional. Now, as you know, as we've talked about before, if something is presumptively true, it does not necessarily mean it's true. For example, when you go to court, if you're charged with a crime, you are presumed innocent. You are presumptively innocent. But that presumption can be overcome. That burden can be overcome by the government beyond a reasonable doubt in the criminal context. So even though you're presumed innocent in a criminal case, you can ultimately be found guilty because that burden can be overcome and that presumption can be overcome. So when things like the Supreme Court in Heller makes a passing reference to these laws seem like they're fine. We're not really getting into it in the Heller case today, but they seem okay to us. All they're really saying is we're presuming that these things are okay, but you still have to do the analysis to see whether or not that's true, because again, presumptions can be rebutted and overcome. Because it happens every day in criminal courts in America. The presumption of innocence is overcome by the government that rebuts that presumption and shows that indeed you are guilty. Likewise, any presumption about these sensitive places can be overcome if the evidence is such that they are indeed not sensitive places. I would say the three likely exceptions to that, of course, dealing with courthouses, polling places, and legislative assemblies, i.e. Congress. But other than those three places, I think everything else is fair game because the Supreme Court only focused on those three items in Bruin and nothing else more generally. Okay, well, hope you learned something here today at the Four Boxes Diner. We'll keep you abreast as things develop in this University of Michigan case. I suspect there'll be an appeal taken to the Michigan Supreme Court. We'll see what happens there. But again, I don't think this court, I'll put a link to it down below, but I don't think the court got it quite right. I think they worked pretty hard on this decision, but I think they weren't sufficiently nuanced in distinguishing the issues involving sensitive places and who's allowed to have guns on these campuses. I don't think they read the cases carefully, if they read them at all. So I think, we'll see if the Michigan Supreme Court takes up this case and looks at it more carefully. Okay, Okay, folks, if you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.